Good morning,
Good morning.
Good morning.
Tammy. How are you?
I'm well. How are you doing?
Good.
It's nice to meet you.
Nice to meet you. Good work with you. All right. Everyone's here. We'll get on the record in cause number DCM-21-2100, State versus Jeffrey Vincent Nicholas. We have a defendant's pretrial motion number 57, which is a motion to continue competency trial. If I can hear announcements from the state and the defense, please.
State's ready, Your Honor.
And Judge, we are somewhat ready. The defense counsel is present. However, Mr. Nicholas is not feeling well and not present today. As it's our position that he is still incompetent, we are not able to waive his appearance for the hearing today.
Okay. All right. Well, I'm going to proceed here today. I got information that he didn't feel well. He didn't want to participate, and so we'll proceed with this motion to continue the competency trial. And let me identify all those present, please. There's a lot of people I don't know who they are. Ms. Brown, who are you?
Your Honor, I'm an attorney with the Regional Public Defender's Office. I work with Ashley.
Hello. How are you?
Hello.
And Mr. Rivera?
Good morning, Judge. I'm Juan Vera. I'm out of Lubbock. I'm the fact investigator on the case.
Okay. And Ms. White?
Hello, Judge. My name is Jamie. I'm the mitigation specialist out of the Lubbock office on this case.
Okay. Ms. Field?
Morning, Judge. I am Sarah Field. I am an attorney out of the Lubbock RPDO office.
All right. Well, good morning, everyone. All right. Ms. Pukshavinsky, I'll hear you on your motion to continue the competency trial.
Thank you, Judge. We did file that official motion on Monday. We're still arguing and requesting that the jury trial be continued. That's currently scheduled for June 22nd of 2026. Our reason for requesting that motion to continue is so that our defense expert, Dr. Bhushan Agarkar, is able to go and examine Mr. Nicholas before that jury trial. When the jury trial was originally scheduled, the purpose of it was because it was a civil commitment proceeding, not for whether or not Mr. Nicholas is competent. So at that point in time, there was no reason that we needed Dr. Agarkar to go in and examine Mr. Nicholas face to face. And so when that was scheduled, it wasn't with any examinations in person being needed in mind. We got after the court scheduled that jury trial that it was going to be changed to a competency jury trial because the state, or not the state, but Vernon State Hospital filed a notice under 46B.079 that they now believe that Mr. Nicholas is competent. After that filing is when the court changed the trial to be one on competency rather than a civil commitment. Those proceedings and the arguments and the things that are going to be presented are very different. There have also been a lot of intervening factors in between when Dr. Agarkar was last able to examine Mr. Nicholas, and now that examination took place in June of 2024, the last in-person examination. And he was able to assess Mr. Nicholas as well before the prior competency trial, but that was in April of 2025. At the time of the currently scheduled jury trial, it'll be over a year since we've had any competency-related examinations by Dr. Agarkar. And that time, Mr. Nicholas has spent additional time in jail awaiting the competency restoration process. He has also gone to Vernon State Hospital, where he's met with a treatment team and various professionals from Vernon. He's also been placed on various medications for various time periods. He's gone through competency restoration classes. He's been in a different facility with different requirements.
Let me interrupt you and ask Tammy, is she violating the speed limit? Okay. All right. Just wanted to know. Go ahead.
And given all those things, it's essential that Dr. Agarkar be able to go in and conduct a face-to-face examination of Mr. Nicholas. It's not that we haven't had anything going on. There's been a lot of different changing factors. We also have two different reports from two different psychologists who are giving two different opinions based upon the information that they've received and reviewed regarding Mr. Nicholas and the competency restoration process that he went through. And so it's essential that Dr. Agarkar go in and conduct that examination so that we can effectively represent Mr. Nicholas at that competency trial. And the statute that allows for Dr. Agarkar to be appointed to us does also say that it pertains, and I'm getting the exact language here in front of me, that they shall testify to the issue of competency or incompetency of the defendant at any trial or hearing involving that issue. And so we need that examination so that he can continue to testify. And it does also give him the right to examine the defendant too. And Dr. Agarkar has also provided an affidavit for the court indicating those reasons as well, why a face-to-face examination is required, and also indicated to the court that he is not available to examine Mr. Nicholas in person prior to that June date. So we are not making this motion for the purposes of delay. We haven't asked for a continuance request for this. At the time that it was originally scheduled, it was a jury trial for a completely different issue. And now that that issue has changed, we've made the court aware as soon as possible that we would need a different date to allow Dr. Agarkar the time that is necessary for him to examine Mr. Nicholas so that we can effectively represent him under the Sixth Amendment of the United States Constitution.
Okay. Mr. Best, any response?
Judge, the state doesn't have a response. Uh, we'll go with whatever the court tells us to do on this.
Okay. In April or March, I guess, of 2025, we assembled in Tom Green County to conduct a competency trial at that time, and it didn't take place, but nevertheless, the doctor did appear for that trial, and he was pursuant to a state's challenge. We had a hearing in which he did testify. My understanding is that he did do a face-to-face with the defendant at the time that he appeared for trial, the competency trial at that time, correct?
Yes, Judge.
All right. Is there any reason he can't do the same thing in June?
Examine him in June during the trial?
Yes, before the trial. That's what he was going to do. And that's what he was going to do during the previous competency trial.
He wasn't going to examine Mr. Nicholas during the competency trial for the one that we had in April of 2025. He had already conducted that examination prior to that trial.
Well, my understanding, he did it. He did another one. 2 years ago, he did one, and then in April of 2025 or March 2025, when he appeared for the trial, didn't he do another face-to-face with the defendant?
Correct, but that was prior to the last competency trial.
Yeah,
So he has not
right.
seen him. But that one was not face-to-face. That was just a visit, the second one in March of 2025.
All right. Is there any reason he can't do it when he appears for trials? Because his affidavit says he can't appear in June of 2025. Is that he can't appear to do a face-to-face update with the defendant before then? And my
Correct.
question is, why can't he do it during the trial if I give some schedule leeway for him to perform that?
That would give us no time to then meet with him and confer and go over his testimony and his findings. We wouldn't have any time for him to write a report. We wouldn't have any time to give that to the state. There's no way to prepare with him doing an examination right then and there.
Well, I mean, the issue is competency, and he's given one report that's 2 years old. He did another face
Correct.
to face in April, and I assume he had the same opinion. So I mean, what I don't understand the not being able to prepare when the issues are all there. I mean, how significant is his opinion going to change? I mean, I guess it could. I mean, but that's just rhetorical. I'm just asking that rhetorically.
Well, there's a lot of different intervening factors. We also have medication. Is that if our doctor can't assess our client and the medication and the effects and the implications of that, it's not as simple as going in and doing the examination and then him coming back and saying, these are my answers. He also has to take that information that he gathers in that examination and apply it to the records that he's reviewed, the reports that he's reviewed, all of the information that he's gathered. And he needs time to be able to do that and then also discuss it with the team, what his findings are, what the implications are, what that means. And then we also have a duty to put that forward in a cohesive manner. We're not able to do that if he's doing that examination and then testifying immediately.
Okay. He'll be here in June, correct? I mean, he can be here. If we went to trial in June, he can be here. There's no question about it.
Yes, he can be here to testify, but his testimony is limited, and so is our ability to use him effectively and provide effective counsel.
If I gave him time to examine him face to face, then consult with you.
And Judge, we're going to need more time to consult with him than him going in and doing the evaluation and then consulting. And this is not something that we do in a day process with him.
Yeah, but I don't understand how much that would his opinion's going to change.
If I knew the answer to that,
Here's the scenarios. Just he could come, he could do a face to face. He could find him. He continues to be incompetent. He could say he's now competent. I guess those are the two scenarios, correct?
correct, but there's more than just saying he's competent or not competent. There's also those 6 questions that need to be answered and explained to a jury. It's not
Six
as
questions.
simple.
6 questions. What 6 questions?
There's 6 questions that the competency statute requires the experts to examine and answer when determining. It's also laid out in Dr. Lambert's report and Dr. Olafson's report.
Okay. And if you know he's already given an opinion regarding the intellectual disability. I I haven't read it, but I believe he favors that he's intellectually disabled. I mean, and if that's the case, if he's reached that conclusion, how I mean he's always going to be incompetent. I would assume. I'm just again, isn't that so? How much is his opinion going to change? That's
I
what I'm
can't,
asking.
I mean, I'm not the expert judge. I
Yeah,
can't give that information. That's the whole purpose
I
behind
understand.
an
I understand.
expert.
I
But the
understand.
state hospital is also looking at this under mental illness grounds. And so our doctor is also going to need time to assess that. And then they gave him medication in an attempt to try to treat some of those perceived mental illnesses, which is also impacting him. If he's not on that medication anymore, that is also going to impact the assessment. There's lots of different factors that go into this. I also don't know if Dr. Agarkar is available to spend a whole week in Tom Green County to conduct the assessment, meet with us, and then also provide testimony.
Well, I'm just talking about a couple of days, like to meet with him, to get with you, and
Correct,
then
but
let's conduct
he
the trial.
in Georgia, it's going to take a good day to get here because we have to fly into Dallas and then you have to fly into San Angelo. The San Angelo flights, there's usually only 3 or 4 a day coming in and going out of. So we have probably a day or two just for the travel to and from. And then the evaluation, the 702, 705 testimony from the last took at least half a day and we didn't even get through all of it. And that wasn't even his trial testimony. So he's going to have probably at least a day, if not longer, of just straight testimony. And then in addition, we also have to be prepared for that. We have to be able to have time to meet with him and actually formulate what we are going to do with him, what questions we are going to ask him. So it's not as simple as just meeting with him and saying, okay, we're putting you on the stand. That would be ineffective of me to not take the information that he's given and put it together and actually come up with how I'm going to ask those questions, what questions I'm going to ask, how am I going to present it to a jury. I won't even be able to do an opening statement at that point because the evaluation won't have been completed. If it will have been completed, then he's going to have to be here longer than a week because he would have to be here before Monday morning when I do my opening statement. And then he's not going to testify until after the state presents their case.
Well, okay, Ms. Buckshevitsky, listen, I really, against my better judgment, I'm gonna give you your continuance, but I really don't see the basis of it. I mean, if the doctor's rendered opinion, he testified very well at the trial, you know, I mean, not the trial, at the challenge hearing. Um, but I'm gonna give you your continuance. Now let's look at a date within a reasonable amount of time. We already had kind of talked about it informally. Excuse me just a minute. All right, when can he reasonably get down to conduct his face-to-face?
He would be able to be out here at the end of June or July to do it. Then trial testimony, that's what we were talking about, the weeks of August 17th through the 31st, but it's my understanding that the court
I can't
have,
make it. I already have a trial then.
correct. So he is free all of September.
Okay. Um, did we talk about the jury selection on the 18th of September and uh, conducting the trial the week of the 21st? Mr. Best, I don't know if you had mentioned something, you had conflict that day. Is Debbie? Oh, Debbie Lamb, did she get on? Is Debbie here? Yeah, Debbie Ells. Yeah. Hi, Debbie. Sorry.
So Judge, um, we're having some pretrial hearings today. And they're two murder trials, kind of in play that are, and my understanding is the two different judges, that's Judge Dusick and Judge Goodwin, are figuring out which one of those trials is going to go on the 21st.
Okay. So you have two murder trials that week. It's just a question of which one's going to go.
Right. One is going to be reset, I believe, to January.
Okay.
I just can't tell you which court.
Okay. So so more than likely you have a trial going on that period of time, correct?
Yes, Your Honor.
All right. How about let's see. Hmm. The October 2nd, and then with trial starting the 5th.
Um,
You'll
and,
have
and
a whole five days or so to recover from your murder trial, Mr.
yeah,
Best.
and Judge, I'm going to frustrate you with every one of your questions that you ask. And so just work with me through this, because every time you mention a date, I'm going to have something that conflicts. So we'll just have to work through that, and you'll have to tell me to do whatever. Just know that the week of the 5th, the first week of every month, is going to be our 119th jury week. So Judge Rios will have a jury trial set. I don't,
Okay.
the hard part about the job, as you know, is I don't know if there'll be trials going that week or
Okay.
not.
Why don't you tell me what date you have available rather
Okay.
than the date you don't? And then
Um,
with Debbie, and then with this Bukshavinsky, you chime in whenever a date is obviously conflicting for you.
so that first week of the month is a jury week. The second week is the 12th a holiday? Columbus
Columbus
Day.
Day.
I think it's
That week I have a trial already, and the next week I have a trial.
okay, so you have just as many. Okay. And then the last week of the month is our Concho Runnels jury week. So we could try and do it then the week of the 26th. Of of course, because again, I don't know if
How
we're
about
gonna.
the 30th of October for jury selection?
Okay, and so then that bumps us into November, and that first week of November is our
That's great.
our 119th jury week in Tom Green County. Um, Second week of November looks like Veterans Day is on the 11th. That might be problematic.
Yeah.
Third week of November, theoretically could
We're
work.
already getting into Thanksgiving.
I'm sorry?
We would be already getting into Thanksgiving.
Yeah, no, that's the week before Thanksgiving.
All
So
right, going back, let's see, that's Columbus Day. Is Columbus Day, is that well, let me see. Genesis. Hmm. What about the 9th of October? Did you say you had? I can move a trial that I have if it's a civil trial.
if we started on the 9th of October, that Monday is a holiday. It's Columbus Day, the 12th.
Yes.
Then we could continue. We could do that week, and bleed into I suspect, Judge, just to give you a heads up, looking at the defendant's subpoena requests that went out.
Okay. Okay. Debbie tells me October 26th would work. Um, your Concho County, Judge Rios is Concho County. So if possibly we could pick the jury on the 23rd and do it the week of the 26th. Ms. Bukshavinsky, how about you?
Judge, I did hear back from my expert. He's available all of October, so October 26th would work just fine for us.
Okay, so Mr. Best, we're looking at jury selection the 23rd
Mhm.
and the trial starting the 26th.
Yes, sir. That's I think we can try and make that work. I'll get someone to cover in Reynolds and Concho. That's fine. The only thing I was going to give you a little heads up about, Judge, is looking at the defendant's subpoena list. I was a little taken aback because I didn't count the number of people on there. There may be 20 people on there. And I don't know if they're going to call those witnesses or not, but if they do, I do not see this being a 1 week trial. Just giving you a heads up. And the reason I tell you that is because we'll be trying this in Tom Green County, and that first week of November is 119th jury week, so you might have to coordinate with the judges on a courtroom if we bleed into that next week.
We'll get it done.
Yes, sir. I was just giving you a little heads up so you
We're gonna
wouldn't
start
be
early
surprised.
and finish late in the day, but we'll get it done.
Yes, sir.
Okay. So jury selection October 23rd with the jury trial on the 26th. All right. Anything else we need to take up?
Nothing from the defense, Judge.
Ms.
Nothing.
Bukshavinsky, a lot of things you put in the continuance motion regarding whether it was it's trying to battle through the competency statute, which is like I mentioned last time, is clear as mud. Um, uh, Whether I set something for a civil commitment hearing, that I don't know whether I did that or not. Uh, I don't remember, but keep in mind that we're going to follow the statute and what that requires. So the issues of mental illness, civil commitment, that probably it's a premature issue. So, we were trying to get through that time and trying to get through that statute, which is unclear at times. So you might be entitled to issues. The evidence of mental illness and intellectual disability at the competency trial, it's going to be I'm going to let it all in. But whether you get an issue to the jury on those is a different matter. And I'll give you a heads up. You better give me some case law that requires that. It looks like the statute is just a simple competency issue, and that's it. But if you have some authority to say otherwise, you let me know. Keep in mind, this is a competency trial. It's not the trial of the merits or anything like that.
Yes, Judge.
So with that said, we are set for jury selection on the 23rd of October, 2026, with jury selection to commence October 26th of 2026. Okay. Is there anything else at this time?
Nothing from the state, Your Honor.
No, Judge.
All right. If you need any hearings between now and then, state or defense, you let me know. We'll get that set. All right.
Yes,
Thank you,
sir.
Judge.
Okay, Ms. Puxvinci, if you could generate an order granting your continuance and with the relevant reset dates, please.
Yes, Judge, I will.
All right. All right, y'all have a good rest of your day.
Thank you, Judge.
Nice to meet you, Judge.
Likewise. Take care.
You too.